So imagine taking millions in taxpayer relief funds, money that was literally meant to save jobs,
Right.
and using it to buy a $5 million equestrian estate.
I mean, that's wild just to start with.
It's crazy. And now imagine this fierce courtroom battle erupting over those exact funds where one side actually brings out like algorithmic Python-coded text matching to mathematically prove that the other side is literally plagiarizing their legal outrage.
It's just incredible.
Welcome to the deep dive, everyone. Today we are opening up an explosive 25-page legal brief that was filed in a New York federal court on July 17th, 2026.
Yeah, and our mission here for you today is to really unpack what is honestly a masterclass in high-stakes legal counterattacking.
Oh, absolutely.
We're going to explore how a really sophisticated legal team systematically dismantles this bullying maneuver, which is known as a sanctions motion. We'll look at the wild realities of Paycheck Protection Program loan allegations and, the bare-knuckle tactics lawyers use behind the scenes when they are truly playing for keeps.
Yeah, when the gloves come off.
Yeah.
But before we get too deep into the weeds of those tactics.
Yeah, I should jump in here. Because we are dealing with government PPP loans and federal enforcement, which are topics that can get politically charged very quickly, we are keeping this deep dive strictly neutral.
Right.
We aren't endorsing any viewpoints, we're not taking political sides, and we are certainly not determining anyone's guilt or innocence. We are purely analyzing the factual claims and the legal mechanics exactly as they are presented in this specific court document.
Exactly. We're just looking at the strategy on the board, like a chess match.
Exactly.
So to understand why these lawyers are currently trying to absolutely obliterate each other over procedural technicalities, we really have to look at the underlying accusations that triggered this entire war.
Right, the spark that started the fire.
Right. So this is a lawsuit filed under the False Claims Act. The plaintiff is a whistleblower company named Tradesman, and they are suing a law firm called William Schwitzer Associates, along with its owner, William Schwitzer.
And for some quick context on the mechanics here for you, the False Claims Act is essentially the government's primary anti-fraud tool.
Okay.
It allows a private party, who they refer to as a relator, to essentially step into the shoes of the United States government and sue if they believe someone is defrauding federal programs.
Wow.
Yeah. And if the lawsuit is successful, the whistleblower gets a percentage of the recovered money as a reward for taking the risk.
Like a bounty, almost.
Basically, yeah.
And the core allegation in this brief centers squarely on those PPP loans from the pandemic era. The plaintiff claims that the Schwitzer firm took over $3 million in forgivable PPP loans across 2 separate draws.
Which is a massive amount of money.
It's a ton.
Yeah.
And to legally receive that money, the firm had to formally certify that, quote, current economic uncertainty made the loans absolutely necessary to support their ongoing operations.
Right, which, that was the standard fundamental requirement of the entire program. You had to swear under penalty of law that you genuinely needed the capital just to keep your lights on and pay your employees, because the broader economy was in a state of crisis.
But the plaintiff's brief lays out this massive contradiction to that claim of financial desperation. They allege that during this exact same time frame, the Schwitzer firm maintained multiple open existing credit lines with a bank, which they were actively extending.
Oh, wow.
Yeah. It goes further than just corporate credit lines. Yeah. The owner allegedly formed a new LLC to purchase a $5 million equestrian estate in New York.
An equestrian estate?
Right. We are talking about dropping a $2.2 million down payment on a property and officially certifying it on the mortgage documents as a second home.
And the real estate transactions detailed in the brief, they actually don't stop in New York either.
They definitely do not. The owner allegedly used another newly formed shell company to put a $1.5 million down payment on a luxury penthouse in Florida. And the name of this shell company, registered on official legal documents, was Frat Boys with Money, LLC.
It is a detail that almost feels too on the nose for a legal thriller. Like you couldn't write that.
I honestly had to read that line twice. Frat boys with money. If we put this into everyday terms for you, it's like a friend coming to you, swearing they're completely broke and facing eviction, and begging to borrow $1,000 for rent.
Right.
You hand over the cash to keep a roof over their head, and the very next morning, they post a photo on Instagram from the deck of their brand new luxury yacht.
With a captain's hat that literally says, frat boys with money.
Exactly. But, okay, put yourself in the defense's position for a second. if you were facing a lawsuit with optics that bad on paper, how do you even respond? Like, do you just file a basic denial and argue that the business actually did need the relief funds?
Well, you certainly could argue the merits of your financial situation, but the defense here took a much more aggressive route. Instead of just fighting the facts of the allegations, they went directly after the lawyers who filed the lawsuit.
Oh, wow.
Yeah, they filed a Rule 11 motion for sanctions against the plaintiff's legal team.
Okay, wait. Let's unpack this for a second. What exactly does a Rule 11 motion do in this context?
So Rule 11 is a specific rule of civil procedure that's designed to prevent lawsuit abuse. When you file a motion for sanctions under this rule, you are asking the judge to formally punish the opposing lawyers.
Like financially?
Exactly. You are telling the court, look, this lawsuit isn't just factually wrong, it is completely frivolous, legally baseless, and was filed with a malicious, improper purpose, like trying to extort or harass my client.
Yikes.
The whole goal is to get the case thrown out immediately and have the opposing attorneys fined for even daring to file it.
So it's basically a kill shot aimed right at the messenger.
Essentially, yes.
I mean, if you are the plaintiff's lawyers and you get hit with a motion accusing you of malicious harassment, you must be furious. I would expect a blistering, highly personalized defense. But the plaintiff's response, which is the brief we are diving into, it takes a totally unexpected angle.
It really does.
They basically argue that the defense's outrage is completely manufactured.
And this is where the plaintiff introduces this really fascinating intersection of law and computer science.
Yeah, this part blew my mind. The plaintiff's legal team didn't just argue that their lawsuit was valid, they included a full appendix titled A Comparative Text Analysis.
Right.
They actually ran the defense's motion for sanctions through a Python programming algorithm using a code library called difflib.sequencematcher to mathematically prove that the defense plagiarized their anger.
It is such a devastating tactical maneuver, primarily because it relies on objective data rather than just, rhetorical argument.
Right. I know a tiny bit of Python, but how does a script actually prove legal plagiarism? I mean, couldn't an algorithm just be matching standard legal phrasing like party of the first part or, I don't know, standard case citations?
Well, that is the beauty of the specific library they used. Difflib.sequencematcher, it doesn't just run a keyword search or flag common vocabulary.
Okay.
It calculates the longest contiguous matching blocks of text. So it looks for the structural DNA of the paragraphs.
Wow.
And the algorithm proved that 28 entire paragraphs, which makes up over 1,590 words.
That's a lot.
Yeah, it's roughly 20% of the defense's entire motion. All of that was lifted verbatim. And they weren't copied from a legal textbook. They were copied from a completely different sanctions motion filed by a totally different law firm in a separate, completely unrelated lawsuit known as the Liakas case.
Unbelievable. The plaintiff's brief shows that the defense literally just used the find and replace function.
Wow.
They swapped the word Liakas for Schwitzer and relator for plaintiff. But let me push back on this for a second because I want to make sure I understand the boundaries here. Is it actually against the rules for a lawyer to recycle a good legal argument? I mean, I use email templates at work all the time.
Sure.
If someone has already written a great summary of what constitutes a frivolous lawsuit, why can't a lawyer just use that template?
That distinction is crucial. Using boilerplate legal language like standard definitions of federal law, basic formatting, or standard introductory phrasing, that is perfectly acceptable, and lawyers do it every day.
Right, that makes sense.
But the algorithmic analysis caught something entirely different. The defense didn't just copy the legal standard for a sanctions motion. They copied highly specific, factual arguments asserting that the plaintiff had an improper purpose.
Oh, I see.
They copied long paragraphs claiming the plaintiff's lawyers were acting in bad faith, deliberately harassing them, and filing the lawsuit without conducting a reasonable inquiry into the facts.
I see. So they copied the factual assertions of harassment, not just the legal definition of it.
Exactly. And that creates a staggering irony here.
How so?
Because Rule 11, the exact rule the defense is citing to demand punishment, explicitly requires a lawyer to conduct a reasonable inquiry before filing any document to ensure that their claims are rooted in the specific, unique facts of their own case.
Oh, wow.
You cannot legally certify to a federal judge that you are being uniquely and maliciously harassed by simply copy-pasting a script of someone else's harassment from a different case entirely.
That is embarrassing. So the plaintiff is arguing that the defense is trying to manufacture a fake drumbeat of misconduct. They want the judge to think the plaintiff's lawyers are serial harassers, but they're trying to prove it using an automated mechanical script.
It completely undermines their claim of genuine indignation. I mean, it is incredibly difficult to convince a judge you are a victim of targeted specific abuse when your cry for help is literally a form letter.
Right. And if they were careless enough to copy-paste their emotional outrage, did they actually check their own facts? Because the plaintiff's brief argues that the defense didn't just plagiarize text, they actively distorted the basic timeline of events and federal statutes to try and make their copied arguments fit this case.
Which leads right into the argument regarding the sequence of events.
Right, the time travel.
Yeah.
In their copied and pasted brief, the defense claimed that the plaintiff only filed this whistleblower suit in retaliation after failing in several other lawsuits, specifically ICO suits.
And ARCO, for those unfamiliar, stands for the Racketeer Influenced and Corrupt Organizations Act. It's a law originally designed to take down organized crime and the mafia, but it is often used in complex civil fraud cases as well.
Right, so the defense paints this picture of a desperate plaintiff throwing a Hail Mary whistleblower suit at the wall only after losing their ICO cases. But the plaintiff points out a massive, undeniable flaw in that narrative. This False Claims Act suit was filed under seal in April 2025. But the very first dismissal of those RICO suits didn't happen until June 2025.
Right. I mean, you cannot file a retaliatory lawsuit 2 months before the event you are supposedly retaliating against even occurs.
It's chronologically impossible.
It violates the basic linear progression of time. It strongly suggests that the defense simply copied that narrative of retaliation from the other case without checking if it actually applied to their own chronological timeline.
Just blindly trusting the template. And it wasn't just the timeline they allegedly distorted. They also twisted the legal precedents. The defense argued the entire case should be thrown out immediately because of something called the public disclosure bar.
Yes.
Their argument was that all this information about the PPP loans and the real estate purchases was already public, meaning the whistleblower didn't uncover anything secret or new and therefore has no right to sue.
Now, the public disclosure bar is a legitimate defense mechanism in False Claims Act cases. It's designed to prevent opportunists from just reading the morning newspaper and filing a lawsuit for a reward.
Sure.
But the specific details of how that bar is applied matter immensely here.
Because the plaintiff points out that the defense cited case law from before the year 2010 to support their argument. And 2010 is the critical year because Congress literally amended the False Claims Act in 2010 to explicitly exclude state and local records from counting as public disclosures that would block a lawsuit.
Exactly.
And what did the whistleblower use to build this case? State UCC credit filings, which are basic public records of a company's debt, alongside local county property deeds and New York State court data.
Right. Under the current amended law, those state and local records are completely valid sources for a whistleblower to use. The defense relied on obsolete pre-2010 case law to try to kill the lawsuit, probably hoping the distinction would just go unnoticed.
And they cherry-picked their modern cases, too. The defense cited 3 specific cases, Shoup, Berkeley, and Kustra, claiming that federal courts consistently dismissed these kinds of PPP claims based on public disclosures.
Right.
But the plaintiff's brief calls them out, exposing that the defense completely ignored the actual legal standard the judges used in those exact cases. They refer to it as the Springfield, or Metesky X plus Y equals Z test.
And this test is fundamental to understanding how fraud is legally deduced from public information in these types of cases.
I gotta be honest, I'm a bit lost in the legal weeds on this one. If I'm just trying to understand the strategy here, why does an algebra test matter to this case? Like, let's break down this X plus Y equals Z concept for everyone.
Sure, yeah. Think of it as a formula for proving fraud. In this legal test, X represents one public fact. So, for example, a company receiving a government loan.
Okay, got it.
Y represents a separate public fact, like
Yeah.
that same company having massive open credit lines and purchasing luxury real estate.
Right.
Z is the logical deduction of fraud when you combine them. In the specific cases the defense cited to support their argument, the plaintiffs in those cases only had X. They simply looked at a government website, saw a company got a loan, and blindly alleged fraud.
Which isn't enough.
Exactly. The courts correctly dismissed those cases because simply getting a loan isn't inherently fraudulent.
So you need the Y to make the equation work.
Precisely. In our current case, the plaintiff is arguing they have X, the PPP loans, and they have Y, the equestrian estate, the credit lines, the Florida penthouse.
Yeah, frat boys with money.
Exactly. When you put them together, it legitimately leads to Z, the inference of fraud. The defense completely ignored this test in their brief because applying that standard would demonstrate that the plaintiff's case is actually legally sound.
So they hid the math because the math proved them wrong.
Essentially, yes.
And they tried another major sleight of hand regarding the Department of Justice. The defense claimed that because the DOJ chose not to officially intervene and take over the lawsuit, it proves the government thinks the case is completely meritless.
Right.
Which, I mean, if I report a massive fraud to the government and the Department of Justice says we're not going to get involved, doesn't that inherently mean my case is weak?
It's a really common assumption, but it is factually incorrect regarding how the DOJ operates. The plaintiff dismantles that argument by pointing out that historically the DOJ does not intervene in roughly 80% of False Claims Act cases.
80%?
Yeah, they simply do not have the manpower or resources to litigate every single whistleblower suit.
Wow. And the plaintiff brings up something called the Granston Memo to prove this point further.
Yes, the Granston Memo is an internal DOJ policy directive. It explicitly gives the government the absolute power to forcefully dismiss whistleblower cases outright if they genuinely believe they are frivolous or interfere with government policies.
Oh,
The DOJ has a mechanism to kill garbage cases quickly, but they deliberately chose not to exercise that power here. They reviewed the case and let it proceed. So by claiming that non-intervention equals a lack of merit, the defense is really misrepresenting how federal enforcement actually functions.
right. So having mathematically exposed the plagiarism, dismantled the impossible timeline, and corrected the twisted legal precedents, the plaintiff moves to the final blow. And this is pure courtroom drama.
It really is.
They expose the sheer hypocrisy of the opposing counsel. The plaintiff's brief literally pulls the receipts on the defense's lead counsel by pointing to a public New York City Council meeting from August 27, 2024.
A matter of public record, mind you.
Exactly. At this meeting, this exact same defense attorney was at the microphone, proudly boasting to the city council that his most significant legal accomplishment was using a civil RICO statute to expose litigation fraud committed by a New York lawyer. But now, in this current case, that same attorney is demanding extreme sanctions against the plaintiff for doing the exact same thing. The plaintiff is using civil fraud statutes to sue a New York lawyer, and the defense attorney is acting like it's the most abusive, unheard-of tactic in legal history.
The brief summarizes it brilliantly. They call it, quote, "a claim for me, sanctions for thee."
That is wild. I mean, it's like a star basketball player aggressively screaming at the referee, demanding a technical foul on the opposing team for a specific crossover move that he himself is famous for using to win championships.
That analogy captures the dynamic perfectly.
Thank you.
And, if we zoom out and look at why a sophisticated legal team would engage in this kind of strategy, it brings us to a concept litigators refer to as legal atmospherics.
Atmospherics, like creating a mood in the courtroom.
Yes, judges are human beings. They're incredibly busy, often managing overwhelming dockets. The defense knows that based strictly on the law and the facts, the shell companies, the Florida penthouse, the credit lines.
The bad optic.
Right. They are in a very vulnerable position. They aren't actually trying to win the specific motion on the pure letter of the law. They are trying to generate a fog of performative indignation to poison the well. If they can paint the plaintiff's lawyers as chaotic, abusive, vexatious litigants who just file junk lawsuits constantly, they might subtly color the judge's perception of the entire case.
They want the judge to be so annoyed by the drama that they just dismiss the case to clear it off their desk.
Exactly.
But the data the plaintiff provides totally refutes that narrative of them being vexatious litigants. The plaintiff's brief lays out the hard numbers for the judge. Out of all their firm's filings, they have had exactly 0 False Claims Act cases dismissed by a judicial decision.
0.
They have had 0 sanctions leveled against them, and roughly 90% of their cases are still active and surviving court challenges. I mean, you don't bat 900 if you're just filing frivolous garbage.
And despite that track record, the defense goes so far as to demand unlawful relief in their motion. They ask the judge for a terminal sanction, which means throwing the case out entirely without a trial, purely as a punishment.
Wow.
Even more brazenly, they demand the judge force the plaintiff to disclose the number of other sealed whistleblower cases they have currently filed against other law firms.
Wait, I know whistleblower cases have strict secrecy rules, so isn't demanding that information illegal?
Highly illegal. Those other cases are under federal seal orders to protect ongoing, sensitive United States government investigations.
Jeez.
The defense is essentially asking a federal judge to force the plaintiff to violate other federal judges' gag orders just to satisfy their own demand for discovery. It is an incredibly aggressive, legally indefensible request.
It's just breathtaking audacity. So, to summarize the incredible journey we've just taken through this 25-page document, we started with a staggering image. Over $3 million in taxpayer pandemic relief loans allegedly flowing into a firm whose owner simultaneously dropped millions on an equestrian estate and a Florida penthouse, all through a shell company named Frat Boys with Money, LLC.
A literal masterclass in suspicious optics.
Right. And from there, we dove into a bare-knuckle legal brawl. We saw defense lawyers file a bullying motion to try and kill the case before trial by aggressively attacking the character of the lawyers who filed it.
Yeah.
We saw the plaintiffs fight back using Python coding and algorithmic text matching to prove the defense mechanically copy-pasted their outrage from a totally different case.
The deployment of automated indignation, if you will.
Exactly. And we saw the plaintiff expose time-traveling legal arguments, where the defense claimed they were retaliated against months before the underlying event even happened. We saw obsolete pre-2010 legal precedents exposed, and the math of the X plus Y equals Z test deliberately ignored.
Right.
And finally, we witnessed the incredible theater of a lawyer demanding sanctions for the exact same legal tactic he publicly bragged about using himself.
It is a
Which brings us to a final thought for you to mull over today. We've just seen the extraordinary lengths required to fight back against these kinds of bullying, poison-the-well tactics. The plaintiff's law firm had to spend massive amounts of time, money, and sophisticated technological effort. Literally coding Python text-matching scripts and pulling decade-old legislative amendments just to defend themselves against a copy-pasted intimidation tactic.
It requires a massive, sustained expenditure of resources just to keep the underlying facts alive in court.
Right. So consider the massive chilling effect this dynamic creates. In a justice system that is theoretically designed to uncover the truth, what happens to the everyday whistleblower? What happens to the mid-level accountant or the warehouse manager who sees massive, undeniable fraud but doesn't have a relentless, highly funded legal team behind them to write Python scripts and fight off manufactured sanctions motions?
Right, they just get steamrolled.
Exactly. How much massive systemic fraud goes completely unpunished in our society simply because the cost of surviving this kind of brutal legal meta-war is just too high for anyone to bear?